this honorable court, on hearing the matter, what had happened during the pendency, some of the petitioners who had appealed this on the tribunal, that they had been disengaged. Only on the basis of that, that matter was disposed of, with directions for them to be taken back in service with some relaxation. That these people were taken back in service, challenging the order. They had approached the Honorable High Court. The Honorable High Court had then
just a second. Hello. Earlier was an order dated 1st December 2023.
But I'm referring to different matter. I'm not referring to this particular case. Similarly situated people who are FCSAs having an strength of about 2 decades. They had earlier approached this honorable tribunal. Well, this is yes. Well, I am just giving an aura in respect of the case because this is not the only case. There are approximately.
Sir, just a second, sir. We don't even know who are you. Why have you come here?
Yes.
First, you have to tell us that. Who are you?
Well, I am FCSA. That is Faculty cum System Administrator.
What is that?
Faculty cum System Administrator is the people who have been engaged in Navodaya Vidyalayas, which are remotely located for imparting education to the people and that to downtrodden classes in the village areas. That's the main criteria. And there, these people were engaged because initially, when the schools were established, there was no computerization. Once that computerization was introduced, accordingly, such people were engaged for the purpose of maintaining a computerization, uploading results, and also imparting education to the children. That is why the nomenclature was used.
Okay. You had come here in OA, in this OA,
yes,
which was dismissed.
Yes. On different pretexts.
Whatever.
Yes.
It was dismissed.
Yes.
You don't know whether it is self-goal or the opponent's goal. Then we went to the High Court.
Yes.
What does the High Court say?
High Court has remanded the matter back to this honorable tribunal only on prayer number 2. That is for regularization.
Only on
but in respect of the earlier prayer, that is prayer number 1, the High Court has not passed a new order because saying that that is not a prerogative, notification has also not been issued to that. But that's the only condition.
So we are not considered only prayer number 2.
Prayer number 2 is a regularization. And that similar prayer of regularization is also pending before the Honorable High Court, wherein stay from the termination has also been accorded.
Okay.
Yes, that's what I'm saying.
Okay. So now your prayer is for regularization, and this prayer is pending adjudication in a repetition of the Honorable High Court. And what is this? What is this MA?
Yes. Apart from that, MA has been only filed in respect of the order which has been passed by the Honorable High Court after remanding, so that it can be taken. Well, apart from this, my lord, one thing more very important. To grant ad interim ex parte scheme notes.
MA so in the instance of the applicant has made the following prayer, page 25 of the issue notice.
You stay in the meantime, because the termination order has already been accorded. Well, they have issued the orders. We have just yesterday only we have come across because they are also issuing the process of.
Is it your case that we should not issue notice?
Yes.
Is it your case that we should not issue notice?
Definitely, you
have to issue notice, so you wait.
Ex parte members.
We will read that. It is written ex parte. You did not open the argument by saying that. Why say this? Since the High Court has demanded, we have to adjudicate on regularization, for regularization. And if your prayer in MA is not considered, your whole OA will get frustrated.
Yes, definitely.
This is you never had argued on these lines.
I have been saying the same only that the words will be different.
Simple. Now, हमारे पास तो MA है ये. Issue notice. Haji, you are accepting notice?
Sir, I am accepting.
आप बताइए.
I am seeking time because I have
टाइम मिलेगा आपको, you will
I
get
have
time.
received this copy of MA day before yesterday.
आपको आप जितना टाइम मांगते हैं आपको मिलेगा. However,
I'm
एक सेकंड, आपको जितना टाइम मांगते हैं मिलेगा, कोई दिक्कत नहीं. However, please understand one thing. The OA was dismissed.
yes.
Totally. However, High Court has held that the dismissal of OA was only partially correct. As far as their prayer, in para A2 is concerned, the tribunal has not adjudicated. So they remand the matter to us. कि इस पर फैसला कीजिए. ठीक है? आपने इनको टर्मिनेशन का नोटिस दे दिया है. अगर मीनवाइल इनको स्टे नहीं दिया हमने और आपने would like to enter into some discussion there, Learned Counsel? You can close the file and you can have you can finish your social conversation or whatever it is. We'll close the file.
Yes, sir.
See, you have a long way to go. There has to be some. It belongs more to you than it belongs to us. And you have come to the court. He has come on invitation. You have come on your own because you feel that you will get some justice here. But if here you sort of concentrating on your case. हाँ जी. एक बार अगर आपने अपने नोटिस पे कर दिया तो हाई कोर्ट ने जो आदेश हमें दिया है इसका क्या होगा? You want to understand from you.
After getting instructions from the department, I will.
क्या लिखा है?
Because Lordship, this is the contractual basis.
हाँ बहुत मालूम है.
Only for 10 minutes.
They are faculty FCSA. अब आप CGT कंप्यूटर साइंस लगा रहे हो जिसके लिए आपने इश्तिहार भी निकाला है.
Yes.
Whether they will participate or not, we don't know. Whether they are eligible or not, we don't know. ठीक है? They are contractual employees. You are replacing them with a regular in terms of recruitment rules. Whether they have a right or not is something to be adjudicated. But today, it is a prayer, and High Court has directed us to decide that. So there is no choice before us. कितना time चाहिए आपको?
2 weeks.
He seeks and is allowed a period of 2 weeks to obtain appropriate instructions and /or file a short reply, shorter than reply to the MA. However, we are conscious of the fact that this OA has been remanded back by the Honorable High Court with a specific direction to us to adjudicate the prayer of the applicants for their regularization in their present positions. In case an interim protection is not provided, not only shall the OA be frustrated, even the directions of the Honorable High Court would not have been considered accordingly, while allowing a time of 2 weeks to the respondents. We restrain them from disengaging the services of the applicants till the next date of hearing, when the prayer made in the MAs shall be substantially adjudicated upon. Exactly after 3 weeks.
See anything now?
25th.
Otherwise, the High Court had granted earlier entry check in the meanwhile. Thereafter, it was being made absolute. It was being pending.
Your contract period is ending on 30th of April. So unless and until that contract is extended, how can we?
No, that's the only condition. That's the only condition. Similarly situated person.
If they require services beyond 30th April, they will issue a fresh contract.
I will just show to your lordship what had happened earlier in the earlier round of litigation. On the next day, my lord, I'll demonstrate everything. They also be given some permission to file some additional documents because that would be required.
Additional documents have to be filed along with an MA.
So that I can at least
serve upon him.
Yes, that's what I'm saying. I will serve upon him in case if the lordship will permit, so that they can file properly.
We don't have anything before us seeking such a permission. And you consider the
25th of April.
Grateful.
Item 25. Item